I'm Nick Brooks, a California attorney, and today we're looking at a different discovery weapon in Macron v. Owens, requests for admission. Emmanuel and Brigitte Macron sued Candace Owens in a Delaware Superior Court for defamation over claims that Brigitte was born male and other conspiracy-style allegations. We're going to talk about what requests for admissions are, when they show up, and how both sides could use them to lock in key facts in this case. A very quick backdrop. The Macron's complaint describes a campaign of global humiliation, an 8-part Becoming Brigitte series, and related content that allegedly recycled false conspiracy claims about Brigitte's gender and the couple's past to build Owens' audience and revenue. They say she kept going even after prior French litigation and multiple retraction demands that attached birth and marriage records. That's the factual context for drafting sharp requests for admission. Requests for admission are written statements where you ask the other side to admit or deny very specific facts or the authenticity of particular documents. Unlike interrogatories, you're not fishing for explanations. You're trying to narrow what's actually disputed so you don't waste time proving easy things at trial. If the other side admits a request, the fact is treated as true for purposes of the case, and silence or non-answers can even be treated as admissions under the rules in many courts. So, in a defamation case like Macron v. Owens, well-drafted admissions can quietly decide half the case before a jury ever even hears it. Timing-wise, requests for admissions live in the same neighborhood as other written discovery. In practice, you usually see them after the pleadings are set and basic discovery has started, when both sides know what facts really matter. Delaware civil rules explicitly treat requests for admissions as part of the discovery toolbox, alongside interrogatories, document requests, and depositions. Here, once the court issues a scheduling order in Macron v. Owens and discovery opens, requests for admissions become a way to lock down things like authenticity of records, prior lawsuits, and what Owens actually said on particular dates. If you're the Macrons, you want Owens to admit as many clean, foundational facts as possible. Sample requests for admissions in this case could look like this. 1. Admit that on or about March 15, 2024, you published a video episode in which you stated that Brigitte Macron was born male. 2. Admit that before July 23, 2025, you received at least one written demand from counsel for Emmanuel and Brigitte Macron stating that your allegations about Brigitte Macron's gender were false. 3. Admit that you have not obtained any birth certificate or government-issued identification document contradicting the French civil records attached to the retraction letters sent to you by the Macron's counsel. If Owens admits even to some of those, the Macrons no longer have to prove publication dates, notice, or the basic authenticity of their records. They come into trial as established facts. Requests for admissions can also go closer to the heart of liability. Courts allow requests to admit the truth of facts and even the application of law to fact, as long as you're not just asking for a pure legal conclusion. In Macron v. Owens, that might look like this. 1. Admit that at the time you published the statements at issue, you had no personal knowledge of the circumstances of Brigitte Macron's birth. 2. Admit that you were aware prior to July 23, 2025, that French courts had rejected similar claims about Brigitte Macron's gender as false. 3. Admit that your statements about Brigitte Macron's birth sex were understood by your audience as statements of fact rather than as jokes or satire. Owens can deny, but every clean admission here trims what the Macrons actually have to prove and sets up impeachment if her testimony drifts later. Owens' side can use requests for admissions offensively too, especially to narrow damages and to show pre-existing controversy. Sample requests aimed at the Macrons could look like this. 1. Admit that prior to March 1, 2024, at least one French media outlet had published allegations concerning Brigitte Macron's gender. 2. Admit that you have continued to appear in public, give interviews, and perform official functions since the publication of defendant statements. 3. Admit that you are not seeking to recover any specific lost contract, employment position, or governmental office as damages in this lawsuit. If the Macrons admit prior publicity, ongoing public life, or limits on categories of damages, Owens' team can argue the incremental reputational and economic harm from her content is much smaller than the complaint suggests. Big picture, requests for admissions in a case like Macron v. Owens are about cleaning up the battlefield before trial, getting both sides to admit basic facts, authenticate documents, and narrow what's really in dispute. They don't look dramatic on YouTube, but they're one of the quiet ways defamation cases get decided, because once you've admitted a fact in a request for admission, you don't get to refight it in front of the jury. If you found this video helpful, please hit like so more people see it. Before you go, tell me in the comments, should courts force parties in high-profile defamation cases to admit or deny sensitive facts about their personal lives, or is that a step too far? If someone you know follows Candace Owens or works in the media and politics, send this to them so they can see how requests for admissions really work. And if you want more breakdowns like this from a California attorney, subscribe and turn on notifications so you don't miss the next episode. Thank you very much.